Make sure you take as much food as you'd like to. It's all there for you. Our tax sale workshop will be presented by Robert Tweedle. He's the attorney at law. You've heard me mention his name before. Whenever you needed a power of attorney or fee prepared, typically I would have a document prepared by his law office. Robert has been practicing law for over 23 years. He's been working with Burnett Title for over 16 years. It's my understanding that he preceded me actually. So he is a native of Highland, Indiana. Munster, Highland.
Same thing. Yeah, but the office is in Highland, right?
The office is in
See, that's
Highland.
what she was thinking.
That's right.
Office in Highland.
Office in Highland, absolutely. And he is knowledgeable about tax sales in Indiana, as well as he has a strong background in probate and estate law. And he's going to present a workshop today. So without further ado, Robert Tweedle.
Well, good morning, how y'all doing? I'm gonna stand, that's all right. I see some familiar faces in the crowd, so it's good to see y'all. For those of you I just met, it's nice to meet you. Donna had asked me to come over and talk about the tax sale in general, and I've got some specific information as well that I try to pass on to my clients because having done this, hundreds probably at this point, a couple thousand of these things. Every time I think I've seen everything that can happen, something else happens. So I'm trying to put notes together so I can sort of impart things that I think people need to be aware of and pay attention to. What I was going to do is kind of just give an initial discussion of like the 30,000 foot view of the tax sale really quick, just to give you a general idea as to what it is. And then I was going to kind of skip sort of actually to what happens after the tax sale process, because I think as realtors, that's information I think is really helpful for you guys, because you're going to encounter these more often. You've got investors that are buying them at these properties, or maybe somebody got one at a tax sale and they didn't tell you about it, and then all of a sudden there could be some kind of issue. So it's important to understand that once you get a deed from a tax sale, there's more that you need to be aware of. So with that in mind, again, I just thought I would just give the basic general overview of the tax sale process. So if you don't pay taxes for 2 consecutive installments of tax, your property is eligible for the tax sale. It doesn't mean that it's going to be sold right after that, because it's going to have to coincide with whenever the next available tax sale is that the county's holding. But that's the time at which it will become eligible. So if the taxes aren't paid and then the property does end up on the tax sale, then it'll be offered for sale by the county, and they'll do that one of 2 ways. They'll either have a live in-person auction, which in Lake County is at the auditorium in the government center, or it might also be an online auction. There are different companies that handle those. Onyx Electronics handles the commissioner's auction in the government center, and SRI typically handles the online auction. And down at Pastor, I printed out just a handout that they have on the SRI website, because I just thought it had some good information in it. So I think that's a good resource and help. It kind of talks about a lot of what I'm going to talk about, but it just gives you some general information. So I thought that would be helpful. And you can go on their website, and Onyx has a website as well. You can go on and they have a list of properties that are offered for sale. The next sale that's happening in Lake County is the county commissioner sale, and I'll explain what that is a little bit later. It's going to happen April 7th, 8th, and 9th. You want to register for that. That registration is between February 3rd and February 20th, and you need to go down to the Lake County Auditor's tax sale department, which is just right on the other side of the treasurer's office. You can just in the back of that hallway back there. And you can go talk to the people there, and they're all very, very helpful in that office. Okay, so properties offered for sale at either the auction or online, and then you're the successful bidder. So now you get a certificate, a tax sale certificate, that is your evidence that you now have an interest in this property from the tax sale. Now, there's going to be a period of time from the time that you bought that tax sale certificate wherein which the owner of the property, or anybody for that matter, can redeem the property. And redeeming it just means that you're gonna pay all the taxes that are owed and all the expenses of the person who purchased it at the tax sale. And I'll go through more specifically later on, what is required to redeem a property. Now, at some time prior to the expiration of that redemption period, depending on the type of sale, there's gonna be a notice requirement. And what I mean by that is, as the purchaser, you're gonna need to determine who are the people who have an interest in the property, and you're gonna have to give them a notice, letting them know that the property was purchased at the sale and that there is this opportunity and time period within which to redeem it, so that somebody is notified and then they're aware of what's going on and they have the ability to redeem it and take it out of the tax sale process. Now, once that redemption period expires, if the property hasn't redeemed, then at that point, you're entitled to take the additional steps necessary to ultimately get a deed for the property. What you'll need to do, actually there's a second round of noticing that has to go on that basically, again, notifies the interested people that the property didn't redeem, and then you're gonna proceed to attempt to obtain a deed for the property. The way you do that is you're gonna file a petition in the circuit court that is asking the court to enter an order instructing the auditor's office to prepare a tax deed to you, transferring ownership of the property. And once you get that order, then the way to finish the process, you take that order, the original tax sale certificate you had, and you're going to take those down to the county. You're also going to have to pay all the taxes that have accrued from the date of the sale, and you're also going to have to bring to them a sales disclosure form, which you're all familiar with, the form that has to go along with deeds, because the auditor is going to prepare that deed, and they're going to record that deed, and you have to have a check too for the recording fee, and they'll take care of it. So then they will prepare the deed, record it, and then you will receive the deed back. And now you are the owner of that property, and you've received your tax deed. So that's sort of the 30,000 foot version of the process. Now, before I go into it a little more specifically to impart things that I think are helpful to know, I want to jump to the end of it, because again, this is important for you to know as realtors is, okay, great, I got a deed for the property, so I'm good, nothing else needs to be done. And in some cases that might be true, but oftentimes it's not the case, because the person that received the tax deed, if they're ever going to want to refinance that property, or if they're ever going to want to sell that property to somebody, they're going to need to give good title to that property, unless of course they're just giving somebody a quick claim deed. And that's where you run into problems. And I think that's where you'll see it as realtors is all of a sudden you're, hopefully you're not getting to the closing table and find out, oh, well, what's all this junk that's showing up on title still? How are we going to give good title? The lender's not going to lend to this. The buyer's not going to accept, a title subject to all these problems. And the reason for that is a tax deed gives you good title to the property, okay? It defeats most everything else subject to, if there are covenants, conditions, and restrictions, easements, things like that are still going to be effective, obviously ordinances and local rules and everything else. But the problem is that the previous owner and other people with an interest are still going to show up on title, because when you got that deed, it didn't clean up the title, even though you defeated all those people. So you got to take this extra step. It's a separate process to clean up the title. That's where it kind of differs from a sheriff's sale, because a sheriff's sale will typically clean up the title for like a foreclosure, but that's not the case with a tax sale. So how do you do that? Well, you file a separate lawsuit. It's called a quiet title action. And basically, you're going to serve notice on all the same people that had an interest, but this time it's just one time around, because it's just like any lawsuit. You're going to file a complaint, and then you're going to serve all those people as defendants with service of process, and then they either have to respond to the complaint or they'll be defaulted, essentially. Now again, sometimes maybe it's not a big deal and you don't need the quiet title. If, for instance, maybe it's a property you're just going to rent and you're never going to sell it or borrow against it. Well, then maybe you don't need to. Maybe it's just a lot next to your house and you just want to grow tomatoes on it or something like that. Okay, well, maybe you don't need to go through the extra process or additional expense of quieting title. But most of the people, at least that I'm aware of, that are buying at the tax sale are investors and they're looking to make money. I stress to them as well that they need to make sure to take care of this, because it takes a while for the tax sale, or I'm sorry, for the quiet title process to run through its motions. And the reason is because, again, when you've gone through the tax sale process, if somebody was going to redeem or try to defend their interest in the property, it probably would have been redeemed, or it would have happened during the tax sale process. So the vast majority of times, these are uncontested matters, right? Nobody's going to fight it. But when you're filing a quiet title, you're going to name all the people that have an interest. But one of the other parties to a quiet title is anybody in the universe out there who may have an interest in this property. Okay. Well, how do you serve notice of process on anybody in the universe who might be out there? Well, the way you do that is you publish a summons. So you can serve them by publication. And that puts the world on notice, as well as the people you notice directly, that, hey, I'm looking to clean up title. So if you're out there, now is your opportunity. Now, when you serve a complaint on somebody, they've got a time period within which they have to file an answer, and if they don't, then they can be defaulted. In other words, you can get a judgment against them without them doing anything. In order to get a default judgment, when you serve by publication, it has to be published 3 weeks in a row, and then 30 days have to go by from the last publication before then you can file a motion to get a default judgment. Because of that, the process is usually going to take no less than 60 days, and usually 60 to 90 days on average. I bring that up because again, if you figure this out right before the closing, there's not a lot of buyers out there, especially if somebody has a lender that's going to wait 60 to 90 days, so you lose the sale. Unless it's an investor who's got cash and they're willing to deal with it, right? No matter how many times I tell my clients this, inevitably somebody doesn't do that, and then they get a buyer, and of course they fixed up the property and they borrowed from Big Lou down the street, and now he wants his money back, and they've got this sale and they're desperate to sell this property. I say, look, I told you, if you knew you were going to do this, once you got that tax deed, you should have just pulled the trigger and done the process, get it done, get out of the way, then you don't have a problem, right? And then that person, for 60 to 90 days, I get a call every day, or they stop by, hey, where are we at? I said, I told you it's going to take a period of time, but you can ask me the same question 50 different ways, but the answer is always going to be the same, right? So understand that. Now, it is important to understand that there is one title company in the state that will issue an endorsement over the tax sale process, or over the tax sale issue. Okay, so that's one way to get things done quicker. It typically charges about twice as much as the quiet title, so you just want to keep that in mind. I don't want you to think there's no options. We can try to figure out what all of our options are.
And who is that title company?
It's Meridian. Meridian is the one that will do it. But here's the thing, and this kind of gets into the other issue, and this is why, as the buyer, it's best for you, for the person who bought the property, to do the quiet title right away. And the main reason is this: you've already done all the noticing, and you have all the information of the interested parties and everything, so you've got everything ready to go, so you know who needs to get the notice. The problem is, and I see this a lot, and maybe you guys have, somebody's buying, and there's a lot of interesting characters out there participating in the tax sale, let's say, and some of them will buy these properties and then sell them to inexperienced investors via a quick claim deed, right? So now all of a sudden they got a quick claim deed. But see, even the title company that's going to endorse over the tax sale, they want to see that you did the process right. Okay, so if you're the one who did it, well, you got access to all the information, or the attorney that did the noticing for you has it, right? If they sell it to somebody with a quick claim deed, and I've been in this situation a bunch, where all of a sudden now, I'm chasing down, trying to get a hold of the other attorney, or I get this a lot where other people are calling me saying, hey, I bought this property, I need to do this or that, can you give me all the information? Like, well, you weren't even my client, you never paid me anything, so I'm going to stop everything I'm doing right now, and I'm going to run to the storage unit, and I'm going to start lifting boxes for you, right? So, just understand that it's not going to get a whole lot of immediate attention. Eventually, do it. Typically, attorneys are going to charge you something just for the time and effort to have to do that. And so, it's good when all the information is available. It's a good time to do the quiet time. Okay, that kind of covers the most important parts of it. But one thing to understand as well, when you buy a property in tax sale, in my opinion, you should not spend significant amounts of money improving it or investing in that property until you also quiet title. because everything you do to clean it up is just one more layer of protection against you, right? Because if somebody shows up and tries to argue that there was a defect in the tax sale process, you know, if the order for deed was void, you know, then you might have problems down the road if there was some defect. Now, arguably, they would have the opportunity during the tax sale, it came and went. But I've seen people contest quiet title actions. Usually, it's a mortgage, right? Because for some reason, lenders they don't pay attention to a tax sale notice, but they sure know what a complaint to summons is, and so they get a copy of that. And say, oh, you know, I got to do something to protect my interests. And then, you know, I typically have to explain to the attorney on the phone, no, actually, that time has come and gone, and they'll usually, you know, just withdraw any objections. But you don't want to risk further investment when you can also quiet title and further protect yourself. One example of this, and I don't know for sure if this is a true story or not, but even if it's not, it's a good, you know, it's a good eye opener, I guess. But I had heard somebody say that somebody bought a property at a tax sale and they didn't quiet title, and then they improved it with a gas station or something like that. And then down the road, somebody showed up and was able to successfully defeat the sale, and you know that person lost their investment in the property. So not sure if it's true, but you know that scenario should drive home the fact that before you further your investment, you should protect yourself. Also, as far as subsequent transfers of any property you bought at a tax sale, never give a warranty deed to anybody for a property that you bought at a tax sale, period. There's only two types of deeds you should give to somebody. One, the easiest is, of course, a quitclaim deed, because that's whatever interest you have. Of course, Donna will tell you, and I don't think we have any lenders in the room, but they're not going to want to see a quitclaim deed as part of a transaction. Okay, that's fine. How about this? I will give a special warranty deed, and it's got the word warranty in it. And all it means is I am warranting against anything that I might have done that would create any problems with the property. Well, that's fine. And that's typically going to be acceptable to a title company and also acceptable to a lender. So, but just you never want to warrant anything you got at a tax sale. Any questions on that so far? Yes.
Usually these properties, the bank will pay the taxes prior to, correct? Are these usually properties that don't have a mortgage on them, or?
I mean, most of the time a bank is escrowing taxes, you know, most loans, but not always, right?
Yeah, not always, especially some types of equity.
So if you don't have a escrow account, it may fall through the cracks because they don't know about it.
That's right,
But
but
that's
they're
why-
gonna get a notice if they have a mortgage, because that's, you know, and we'll get into that as well. That's one of the ones that we hit the hardest with notice, okay? Because who are the ones that are gonna redeem? Who are the ones that are gonna have an issue? It's the property owner or a mortgage,
Right,
are the
they
two
got the most
biggest
into it,
ones.
right?
That's right, that's right. So, but yeah, if they're not escrow, and you know, there are a million reasons why taxes don't get paid, right? And you know, typically the people that don't pay their taxes have a million reasons for lots of things. So, but you just, you see kind of a pattern of behavior. All right, so let's go back to just starting with the actual tax sale process and just kind of run through it and address things. And stop me if you have any questions along the way. First of all, you know, there's the way I see it, there's two general philosophies with the tax sale. The most common and the one that we typically are going to see is the philosophy is I'm an investor, I'm buying a property to basically make money, or maybe I want to, either way, it's the goal is to obtain ownership of a property. However, there are these national organizations out there, these tax lien associations where they canvass the states and they look at different states that have a simplified or favorable tax sale process. Indiana is one of those. So we get a lot of out-of-state investors here. And some of those people pool money. And you know, when you have to redeem your property from the sale, you've got to pay interest on the money that somebody spent. And so you're making interest on the investment. So arguably, if it does redeem, at least, you know, you got something for your time. Well, you know, interest on a couple properties, I say it's better than a poke in the eye, right? But it's, I mean, you're not in the business to make a couple dollars of interest or something like that. So it doesn't make sense then. But if you're going to deploy, you know, $2 million in a tax sale, maybe on properties that are likely to redeem, well, then, you know, if you're making 5 or 10% of your money, that might not be a bad investment. So that's another philosophy. But you're only going to see that strategy with, you know, some of the bigger people out there that are, you know, going around the country looking for a place to park money and try to make some money. So most of the time we're trying to get the property, which is why we want to make sure we do things right. And, you know, the tax sale, it's a risky process. There's a lot of little traps and tricks. You don't have to have a lawyer to handle it for you. I strongly recommend it. Obviously, I'm biased because I can't do these types of work. But even if you go to the sale, the first thing they're going to do is come up and say, "Hey, you guys, get an attorney to do your noticing. Don't play around with this. It's not worth it." Okay. I've seen people make some home runs. I've seen quite a few home runs. People might buy a property at a commissioner's sale for $500 and then sell a portion of it off to a car wash or somebody else and get $500,000, just for a piece of the property. I've seen things like that. I've seen people get left behind as well for various reasons. So you don't want to be one of those people. And I want, as an attorney, I want my clients to succeed and be successful. I want them to get properties, make money, and come back, and keep it going. So that's why when I take on a new client, I try to go through some of these things with them and explain to them stuff that I think they need to know, because the last thing I want to hear is, "Wow, I had no idea that could happen." So I kind of go through this whole litany of possibilities, and even then something can happen. But at least that way, I feel like I've done the best that I can to help them to be successful. So there's two types of sales. First of all, we know that the property is first eligible for sale after 2 unpaid installments of tax. At that time, the property is offered for the county treasurer's sale, okay? And if it doesn't sell at the treasurer's sale, then all those certificates that didn't get sold will then be transferred to the county commissioners, and then the county commissioners will, subsequent to the tax sale, hold a commissioner's sale. And there's significant differences between the two. First of all, the first sale, the treasurer's sale, the minimum bid at the auction to get that property is going to be the unpaid taxes. Okay. At the commissioner's sale, it didn't sell for the unpaid taxes, so they can pretty much sell it for whatever they want. And all those taxes that have accrued up to the date of that sale that aren't generated by that sale price are just wiped out. Okay. And the idea is, hey, we want to get this property producing again and people paying taxes on it, so it makes sense for them to do that. So, again, they typically will set the minimum bid. I see a lot of times the minimum bid's like $500, for a property at that point. Oh, wow. So I got a great idea. How about this? I see a property that's up for the treasurer's sale. That's kind of a lot of back taxes to pay for it. I know it. I'm going to just wait until it comes up for the commissioner's sale. I'm going to buy it for $500. Imagine that nobody else has ever thought of it. Right? So I just tell you, because if it's a property that you can live with the price and you really want it and it's be a good investment for you, consider that, because I've seen, many times a property didn't sell to treasurers because other people had their eye on it, and then it goes to the commissioners and sells for, way more than what you could have picked it up for the treasurer's office. So just one little helpful hint there. Now, the other significant difference between the two is the time period, the redemption period, the time in which the property owner, or anybody, because again, anybody, you don't have to be the owner, anybody can redeem a property from a tax sale, but unless you have an interest in the property, why would you, right? But so that time period within which to redeem the property for the treasurer's sale is 1 year from the date of the sale, okay? Now, the commissioners is drastically accelerated. It's 120 days from the date of the sale. So that speeds up things that you need to do considerably when you're buying properties at the treasurer's sale. Also, as far as the amounts needed to redeem the property from the sale. The treasurer's sale, the redemption amount is 110% of the minimum bid. If it redeems before 6 months, if it redeems after 6 months, then that goes up to 115%, which typically we don't give the notices till right before that time period. Also 5% per annum on the amount that exceeds the minimum bid, plus any subsequent taxes, because you can continue paying the taxes that have accrued from the sale date if you want to, and then that gets added to what needs to be paid in order to redeem, and the costs of giving notice. In Lake County, the costs of giving notice for the person who buys it are capped. They will allow you to be reimbursed up to $250 for the title search and $800 for attorney fees and costs of giving notice. And it could exceed that depending on the amount of notice that has to go out. The other thing that's different is the time period within which you have to get your notices out, because with a treasurer's sale, you have to get all your notices out to the interested parties within 6 months from the date of the sale. And for the commissioner's sale, those notices have to be out by 90 days. after the date of the sale. So you can see that that really throws things into high gear if you're buying properties at the commissioner's sale. Now, we talked about the actual process itself. It can be in person as an auction or online. So you can check with the county auditors, tax sale department if you have any questions, and they'll typically give you you can get a package of information to register, okay? And also, if you're gonna bid, make sure you have the money available. You don't want to be a successful bidder of a property and not have the money. Trust me, that's not gonna be a good thing. All right, so any questions so far? Okay, so now we're a successful bidder and we won the auction. So what do we do next? Well, if you remember, I said that you can be reimbursed for your costs of giving notice and obviously what you spent for the property. But in order to secure and protect that money that you need to get paid back, you have to take another step with the tax sale department. You have to file a form that essentially lists out what your costs are, so that if somebody comes in to redeem, then they have to pay that as well, and you're not out that money. That's called a 137B form, and that will get filed with the county. They're very picky about what you have to do to be able to do that. You have to actually spend the money. You can't just say, oh yeah, I spent this and you haven't spent it. So they want paid receipts. They want the attorney's statement says paid in full. They want the title work bill marked, with the stamp on it, paid in full. Because if you think about it, it makes sense. They don't want people just throwing that in there and then somebody comes and redeems. They got to pay you all kinds of extra money and you didn't even have to spend it. Well, that's not fair either, and it makes it harder for you to redeem the property. And what I try to do is, before I'm actually spending money on a property, is I want to make sure that property didn't already redeem. Because you don't want to go buy, spend money on title work only to go back and say, oh, it's already redeemed. I just wasted that money, right? So in Lake County, the only way you can do that, in some counties you can actually just call them up and they'll say, oh yeah, I'll look it up for you. Lake County has so many properties in the tax sale, they can't do that because they would just constantly be on the phone doing that. So you have to go into the county and check on the county computers. Is it available remotely? No. Should it be? Yes. But anyway, that's not, and you have to go in there. There's two computers. But when you walk into the government center, right in the auditor's side, they got two little computer stations set up. There's also one in the tax sale office as well. And so you punch in and then you make sure that it hasn't redeemed. And I'll tell the clients, I reserve a reasonable amount of time to check because I don't want to get left holding the expense. But in reality, what I'll literally do is I'll go down there, I'll pull it up on the computer, check the properties, then I'll run down to the title company, pay it, and then run right back with the receipt. And so, if somebody redeemed within that hour's time, well, what can you do, right? But that's important. And I also want to do that before I spend money on postage, because you can imagine if you're sending out 1,000 letters, that's a lot of stamps and a lot of expense, and you don't want to have like $1,000 worth of stamps sitting in your desk for no reason. So those are all important things to understand. Now, as far as the notice process itself, if I can impart one thing to you with this tax sale process, is it's all about notice. You're realtors and you all know about the 3 L's, right? Location, location, location. So I want to say it's notice, 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 because if you're going to mess up or something's going to happen, that's 90% of the time. That's where the problem is going to be. So as we said, you got to give notice to all interested parties. Well, how are you going to find out about that? You're going to do a title search, right? And that title search now can assist you with the search, obviously.
$250. You have it within 24 hours.
And that search is going to hopefully identify all of the interested parties. And actually, when I do the process, in my agreement, I say I'm only going to be responsible for what shows up in that tax search. The format of it should be it identifies the parties and provides contact information for those people, because that's what I want to see in a report, because that's what I'm going to use. Now, is that where I'm going to stop? Absolutely not. Okay, but I'm not a title company, so I can't take on the responsibility of making sure that all the interested parties are identified. But what I mean by that is, I'm not just going to take that search, as good a job as Donna's going to do. I want to see the documents. I want to see that last deed. I'm going to scrub that thing, because you don't want to be in a situation where you're fighting with somebody. So I'm going to scrub it for any information I can. Mortgage, I'm going to read that whole mortgage. I want it, because some mortgages will have like a little notice provision, like buried in the middle of the document. You just never know. You want to pull all that stuff. Judgments show up. Judgments are kind of difficult because, a lot of judgments are like small claims judgments. The important ones are, foreclosure judgments and things like that. So at some point you got to kind of draw the line as to the notice, and you give, like, for instance, when you see a title search, somebody with a common name, there might be, a million people that have judgment against John Smith. So are you going to send out a million, notices? Probably not. In the rarest time when that happens, we try to look at it, talk to the client, be reasonable, because that could significantly increase your expenses. But again, the ones that are going to be the most important are any way we can get notice to the property owner, and also any mortgages at that time. If I see a company or a corporation, I'm going to pull up the Secretary of State's records. I'm going to go through that. I'm going to look for all the principals, especially if it's a mortgage, right? I'm going to find any way that I can get information. And sometimes when you've been doing this for a while, there's some people whose names pop up a lot, in these searches, and so there might not even be an address on the title search, but just having done it, and I know that myself and some other attorneys that do it a lot, we might have a kind of our own little database of people like, oh, it's that guy. Yeah, he's got a PO box in Munster or somewhere else, and we might even add an address just to be sure if we think it's going to be an issue. So we talked about the time requirements. Again, the first. Hold on. Let me talk about the ways to give notice. No, hold on. For the timing of giving the notices, again, for a treasure sale, you've got a long period of time, right? So it's not an emergency. And by the way, in order to be able to file your 137B for a treasure sale, you actually can't even do it until 30 days after the sale. So they want to give the owners an opportunity to go in and redeem it without having to pay all those extra expenses. For the commissioner's sale, since it's so quick, you can get your 137B file right away. Also with the notices, those notices have to go out in 9 months. So I tell my clients, as soon as you're the successful bidder, take that receipt with the property information, the short legal description, the tax number, just bring that, because that's enough for me to get going on it. You don't want to make a rookie mistake, which is wait, because you will eventually receive the tax sale certificate in the mail. And it might be a couple weeks before you get it. But sometimes it can get held up, or it can take a while. I've seen situations on a commissioner sale, somebody comes in, hey, I just got my certificate, will you do this for me? And then I say, well, there's only, a month left or 30 days left to do it. And one of the things I try not to do is rush the process, because that's when mistakes get made. And if it's really close to the date of the sale, unless it's a good client or some exceptional reason, I won't take it. I might punt it to somebody else who might take it, because I don't want to be in a situation where there's a problem or where we're crunched, because noticing and sending out and doing all the things you got to do, it takes work and it takes time. So, keep that in mind. And there are no extensions granted. In this county, it used to be that if you blew the noticing period, the county would grant an extension of the redemption period, and then they would do it one time for you, and then you would get a new time period within which to do your noticing. Hopefully you do it right the second time. But believe it or not, one of the property owners who got an extra extended time still lost their property, and they filed a lawsuit. Said, hey, the county doesn't have the discretion to extend the time. That's not in the law, and they won that suit. So now there's absolutely no extension. So if you don't do your noticing on time, you stand to lose your investment. So it's very important that you get all that stuff out on time. Now, as far as the title itself, again, it's not title insurance. This is just a search. So you can't expect if the title company misses something, not that they necessarily are, but if they do, I don't even think you can buy title insurance on a tax sale certificate. So you might be reimbursed the cost of the search itself, but you're not going to be able to file a claim and do more than that. Now, as far as how do we give the notice, the most common way, of course, is mailing. And we're going to mail it to the last address of record and then to all the addresses that show up on the title work. Now, when I mail, we do it 2 ways. One is certified return receipt, because there's nothing better than sending out that notice and getting that green card back that somebody signed for. They received it, right? But imagine that people that aren't paying their taxes might not want to also sign for a certified letter, right? So they refuse it or they just don't go pick it up, and now it comes back to you. So what do you do then? So along with every certified letter I send, we always mail regular mail as well. Now, some people will just photocopy the letters to show that they put a stamp on it that they sent it out. I think it's more important than that. And also, by the way, the post office is not going to deliver a certified letter to occupants, okay? But occupants should always be somebody that you're trying to give notice to. So the way we do that is regular mail, but I do regular mail with proof of mailing. And all that is it's a little, it kind of looks like a card, and it's just a little piece of paper with the information, and you got to put extra stamps on it, so it does cost extra, and then they'll cancel that out, and that's your proof that you went to the post office and you sent regular mail. So that's really important. The other way is publication. Now, publication is optional, and the reason is that it's supposed to be you publish in a periodical of regular circulation in the county where that property is located. Well, guess what? In Indiana, there are some counties that are so sparsely populated they don't have a publication of regular circulation. So, by its own definition, it's not possible in some places. So that's why it's optional. If you got a really important property, it certainly doesn't hurt to publish as well and say that you did it. But again, that adds extra cost, so that's what you got to factor in. I wouldn't say you have to do it, but I always recommend it in my opinion. Now, possibly one of the even more important ways to give notice is not even in the statute itself. Well, why is it a requirement then? Well, because there was a Supreme Court case that came down that basically said you got to do everything you can to try and get notice to somebody. And the way that you do that is to post notice on the property. The way that I do it is I have a special process server go out, and they actually will tape the notice to the property, take digital pictures, and send that back to me. And then they sign or return the affidavit that they went out and did it. If it's vacant property, I've got a stake where you just peel off the little sticky thing and just stick it to it and pound it into the ground and take a picture, and you got a piece of grass with the notice. But at least you've done everything you can. And I tell you, there's nothing more powerful as far as proof that you did your noticing when you got a digital picture and some guy is standing outside of his house where the notice was just taped, and he's looking at it, he looks at you like, what are you putting next to it? Snap, so that's pretty good proof right there that that guy got notice that his property was sold to tax. So keep that in mind. So both notices, 4.5 and 4.6 notice, you give notice the same way. Obviously, if the property redeems, you're only going to be spending your money on the noticing for the first round, because the second round of the property is redeemed, so the process is over. Questions so far? Good, okay. So now the redemption period has expired, the property has not redeemed, and you're ready to proceed to try and get a tax deed for that property. So again, how do we do that? We're going to file a petition asking the court to enter an order ordering the county auditor to issue a tax deed for the property. Now, in a lot of counties, all you do, it has to be filed within 3 months after the redemption period is over. Otherwise, you lose the ability to file. Most counties, that's all it requires, and you go and do it yourself in court and then wait for the judge to enter the order and return that order to you. Lake County does it a little differently because in this county we have a much larger tax sale. There are a lot of properties, and so what they do is they will set a hearing date for all those petitions for deed to be heard. We call it the cattle call. And the purpose of it is to basically winnow out all the uncontested properties and reduce it to the few that actually would be contested. Okay, so the way that works is they're going to schedule it typically 2 months after the sale date, because to file a petition before a hearing, you're supposed to get it filed 30 days before the hearing date. So the redemption period is over, and then you need to go and check and see if the property actually redeemed. And of course, you want to give a couple days to the people in the tax sale department to process that. Because again, imagine if people aren't paying their taxes, those might be the same people that wait till the very last day to run into the office and then start paying their taxes. So they're kind of overwhelmed on that day, and it usually takes them a few days for the dust to settle and to update the records. Then you go in and confirm that it didn't redeem, and therefore you need to do the rest of the process. So that's why it's 2 months. So usually you just want to make sure that within a month after the redemption, you get all your petitions together, because you want to get it in on that next hearing date. So the hearing date happens in the main circuit court courtroom. Typically, what we'll do is we'll meet with the attorney for the county auditor's office during the week prior to that hearing. Because you can imagine it'd be really hard for them to review and confirm the notices have all been done properly, all at the hearing. So we'll bring it in all of our paperwork and meet with them, and then they have a chance to kind of go through that stuff. So that at the hearing date, when my name is called, they go up, and the county says, yes, we reviewed Mr. Tweedle's notices, everything appears to be in order, we have no objection to his petition for deed, and then there'll be a list of the hearing, all the properties in the hearing, and I'll say, Judge, I'm on this page of the call, and I've got starting at this property down to this one, these are mine, and we're asking for deed, and the judge says, all right, those petitions are granted. Bam. The process is over, and then I have to wait to receive the order. Now that we have electronic filing, typically I'll get an email with the order. It used to take about a good month or even longer to get the orders back. I'm finding that that's happening a lot more quickly now. So usually within probably 2 to 3 weeks, I'm going to get that order back. And then at that point, then I'm going to be calling the client to say, hey, you need to make sure to be ready to pay those taxes because now I want to take that order and the certificate and the sales disclosure form and a check for the recording fee and bring all that stuff down to the auditor's office so that they will then begin to process the deeds. Now, as far as the taxes, how do we make sure the taxes are paid? Again, with a treasurer's sale, a year has gone by, so you can have quite a bit of taxes that have accrued. A treasurer's sale or a commissioner's sale, it's not as much because it's such a shorter time period. But you can't just go to the treasurer's office and pay the taxes. You got to go to the auditor's tax sale department, and they will prepare a little tax bill for each property with the amount that actually needs to be paid. So that when you bring everything down, I'll usually just go right over to the treasurer's office, pay that, and get my stamped receipt. And then I bring everything to the auditor and give them everything to then eventually process the deed. How long does it take to prepare the deeds? It kind of depends on how quick you get down there because again, there's a lot of properties. So if you wait a long time to pay the taxes and get down there, chances are, there's gonna be a lot of people in front of you. But the process itself, because people always ask me, well, how long is the whole thing take? And I say, look, probably add about 4 months to the end of the redemption period. So if it's a treasure sale, a year, then 2 months to get the hearing, then a month to get your order back, and then a month to get your deed. That's a safe assessment. It could be quicker than that. It could take longer. And then same thing with the commissioners. So you got 120 days and then add 4 months to that. And that should give you a reasonable idea as to when you can expect at the end of the process, if you did everything right, to hopefully be the owner of the property. Now, keep in mind, and I think that kind of makes sense when you think about the hearing that the county schedules, that's for uncontested matters. Well, you could have a contested matter. How does that typically happen? Well, most of the time what I see is, if a person has gotten notice, they're going to redeem the property within the time period. So oftentimes what you're going to have are people that couldn't afford it or weren't able to do it, or you'll get, these situations, and sometimes they could be, pretty unfortunate situations. Maybe somebody who's getting divorced and their spouse out of spite, threw the notice away or something, or maybe like a kid who doesn't know what he's doing, got the notices and just did something with them, and the person didn't know. You can imagine. So you're going to get people that are, technically you're supposed to file an objection, 30 days before the hearing date. Oftentimes you're not going to see that. You're going to see somebody kind of wandering in to the courtroom, like, I don't know what's going on, I'm going to lose my house. I don't know, I don't understand this. I didn't know this was going to happen, right? I didn't know that this was happening. So that's not going to be considered and decided at that cattle call hearing. What's going to happen is they're going to have a block of days set, maybe a month or two after the hearing date, and somebody shows up, they're going to say, okay, fill out this form with your contact information, and they're just going to start filling up these days with hearings. And then you show up at that hearing, and it's going to be a status hearing. And now you're into, a litigation process, essentially. So, be aware that if somebody contests it, even if they don't have, even if it's not a great reason, the court's been a little better at the hearing. If somebody raises an objection that isn't a grounds to contest it, the court will now say, that's not a valid objection. I'm going to grant the order. But if somebody says they didn't get notice, that's a ground for objection. So they're going to set those for the hearing. You can bail on the process at any time. I try to tell people, look, typically, for the actual process itself, maybe it's a flat charge, for that. But if it's contested, you usually got to build in some time, hourly time for that, because it's going to be, it could be a year or more of litigation before you ultimately get the deed to that property. So, I tell people if it happens, if you decide you just don't want to proceed, you can drop it, or if you really want the property, you can pursue it as well. It's just there's going to be more to it to get that deed. And understand there's a lot of different ways you can work these things out, right? So if you can maybe settle with that person, or maybe that person just wants to rent from the person that bought the property. All different kinds of ways. So you're not stuck in the process if you don't want to be. Another important thing to understand, and by the way, when it's contested, keep in mind that judges are people too, right? And when somebody is threatened with losing their home, if there's a way that they can side with that person, they might want to have an opportunity to do that. So that's why, in those situations, it's very difficult. You want to make sure, but your client or you, if you're the property owner, you're doing this to get a property. So you got to be prepared for that, and that's why you want to notice everything right, so that everything's ironclad and you're going to get that property in a situation like that. Also understand that someone might file bankruptcy prior to the time that you get a deed to the property. Now, that can really throw a monkey wrench in the works, and you can end up being part of the bankruptcy estate. And most of the time people don't have huge amounts of money invested in these properties, but I've seen where somebody's got 6 figures in on a property, and then the person files bankruptcy, and you got to go along for the ride. There's not a good Indiana law. This is bankruptcy law is federal law, and we're in the 7th Circuit, which is based out of Illinois. There's not a good Indiana case on that matter. There is an Illinois case, and the Illinois case just kind of says that you become part of the bankruptcy estate. You are, with regard to what you spent for the property, you're a secured creditor with regard to the property, but with regard to anything else, you're just basically an unsecured creditor. And in that case, usually you got to get somebody to help you with the bankruptcy. I'm not a bankruptcy attorney, so I have a colleague that does a lot of that, and so I usually pass it off to that person at that time. Again, it doesn't happen often, but it's a possibility, so you need to be aware of it. So, and then of course, once you get your deed, then you should quiet the title. That kind of gets you to the end of the process. There are a couple things I think you need to be aware of, again, that are helpful. First of all, a tax sale is buyer beware, all right? Whatever you do your due diligence before you buy a property. I hope none of you ever come into my office and say that, oh, well, I bought a property because I went up on Google Maps and I saw a roof, there, and so therefore I bought it. That's the worst thing you could possibly do, because there might not even be anything there anymore, and it just might be an old satellite image, but that's not good information, okay? You want to check out the property, drive by it, do whatever you can to get some information about the property, and definitely use the county GIS program. Are you guys familiar with that? Okay, you go to the county assessor's site, and then you can go to the GIS portal. Super important, okay, because what's that going to do? That's going to give you an actual image of that property, okay? I can't tell you how many times I've had somebody that bought a 10-foot strip of property, between 2 houses, or half of a garage, or something like that, or somebody bought a cemetery once.
Retention pond.
Or retention ponds all the time, because what happens with these subdivisions, what you're supposed to do with the subdivision, if you're responsible developer, is you'll typically create an association, right? There's not a lot of common elements or common areas in like a residential subdivision, but a detention pond is one. You might have like a sign or a little decoration in the front or whatever, but they don't do that, and so there's no association or anybody who owns it, and then they go up for sale. And I see those get bought all the time. And you can't do anything with it because it's already platted as a detention pond, so you're not going to get approvals to do anything. Maybe take a swim. That's about it. Let's put it this way: you're going to take a bath either way. No pun intended.
A lot of landlocked parcels I've seen.
Landlocked parcels, you got to do your due diligence. I mean, just going to the GIS can save you so many headaches. And people just don't know about the GIS. So I'm glad that you're all aware of that. Now, if you buy a property, that's not your property. Until you get a deed, it's not your property. So what can you do? can you go in there and break in or walk in and check things out? Well, I don't recommend it, and it's a good way to get shot, right? So you gotta be really careful with what you do on that property. As far as when you bought the property, okay, you can't go on it, but there are limited exceptions in the law as to what you can do, because what you don't wanna do is just let it sit there and look, keep falling into disrepair, and then a year later, you're gonna get that property. There's not gonna be a pipe in the building, right? So they're gonna come in, they're gonna demolish, and maybe, might even get demolished by the county, or by the town, which I've seen. Imagine that, you bought a property, a year later, you come back thinking you're gonna work on this property, and all there is a hole in the ground, and to add insult to injury, there's a demolition lien against the property, right? So, keep that in mind. Check with the city or the town and see if there are violations. Usually you'll see if there's a bunch of red tags stuck to it, okay, that's an issue. All those violations prior to the sale, you're gonna give notice to the city or the town, so that stuff's gonna be wiped out. But moving forward, there could be like weed liens or, broken windows, and all that stuff is gonna keep accumulating. You can oftentimes let a city or town know that you bought it, and maybe they can help you to come to some understanding. Now, what can you do legally on that property without trespassing? The statute says that you can secure the property, okay? You can remove trash and debris. You can landscape and maintain it. So I think if nothing else, that's important. If you keep it mowed, it looks like somebody's there, or keeping an eye on it. And you can remove graffiti. So those are things that you can do as a tax sale purchaser, and you can't be prosecuted for trespassing if you stay within those requirements. Be careful what you own. Now this isn't as big of a deal with residential properties, but if you buy a commercial property, environmental issues can be a big problem for you, even if you get rid of the property, okay? Because and I've got some experience dealing with the EPA and IDEM, and you don't want to be in the chain of title in a property. These environmental laws, they're full of all these wonderful acronyms. There's an acronym for everything. But what you don't want to be is what's called a PRP, which is a potentially responsible party. If you are an owner in the chain of title and they decide to go clean up that site, they're gonna go after all the people that were in the chain of title to contribute to the cleanup costs, which could be, astronomical, depending. So, if you think there was like a dry cleaner on the property or some environmental issues, maybe you don't even want to mess with it, okay? Or I had one guy bought a property, went down the basement, and said, "Oh man, what are these things here?" He kind of like shook it, all of a sudden, fuel oil tank breaks and fills the whole basement with oil. Okay, that's an environmental problem. Okay, so again, buyer beware. And you can get stuck, obviously, with the property. It's really easy to own a property, but do you guys ever think about what if you don't want to own a property? Okay, how do you just not own a property and nobody wants to buy it from you? Well, and by the way, now you own it, and perhaps you're liable if something happens on that property, right? So you could just let it, again, go for several unpaid tax cycles, and then hopefully maybe somebody will pick it up at the tax sale, and it's not yours anymore. But maybe it won't, because a lot of these properties, will just cycle over and over, and keep showing up on the tax sales. So there are some creative ways to do it. I had one guy who actually knew a homeless man who bought him a carton of cigarettes and said, "Hey, you want to own this property?" "Sure." So he deeded him the property, and now he doesn't own it anymore. So you can sue the homeless guy, I guess. But there are different ways to try and not own a property. There are, now let's say, for instance, you realize you don't want a property. You can also, before you're the owner of the property, you can just not proceed. Of course, then you lose your investment. However, there is a provision that says if you can demonstrate that you made a good faith effort to comply with the noticing requirements, you might be able to get your money back less than 25% penalty, but you're going to be disqualified from the next sale. And so that's another possible option. So those are things that I think are important to understand, and I'm sure there are a couple others, but those are the ones that I think are the most important. So any questions about any of them?
Yeah, we're gonna get a copy of the notes.
I don't have to be able to read these. They're kind of like, I tell you what, well, I tell you what, how about this? Because again, you're gonna go through these, it's hard to go through it. If you look at that SRI handout, that's got a lot of good information. I'm gonna leave cards here as well, so if you guys have a question, you can pass it if you want. Feel free to call me. I like talking about the tax sale, so I'm happy to answer questions for you. If you think you want to participate in it, I'm happy to have you come in. I can go over with you and just kind of explain it. But I think that should give you a really good overview. And also, I think in the handout, it shows you the most important provisions. Basically, in the Indiana Code, if you want to write this down, the notice is it's 6-1.1-25. Actually, 6-1.1-24 and 25. Those are the provisions of the Indiana Code. I've got the book, but you can punch that into the computer and you can pull that up too.
You say that again.
Yes.
Yeah, it's Indiana Code 6-1.1-24 and 6-1.1-25. 6-1.1-25. Yeah, and like I said, the SRI handout has a lot of reference to that as well. It's helpful. It's kind of hard, a lot of parts of that because they're all cross-referenced like 20 different ways. So it's like you got to keep going forward with that. But ultimately, it's fairly understandable. So yeah, I mean, if you don't have any other questions, I appreciate you coming out. I think that hopefully gives you a good understanding or overview of the process. Maybe more detail than you wanted, but
Sounds scary.
Yeah.
what I would say is this: if you're a first timer, have an attorney do your noticing. It's worth the cost. Okay, and maybe after a while you can do a pro se, but I just don't think it's worth it to me. I think it's a cost of doing business. And then at least you can have some comfort knowing that chances are, notwithstanding something, again, unforeseen, because there's always a chance for something new to come up, that you should be hopefully successful and make some money and continue to participate in the process.
What is the average legal fee that you would charge if it went the way you like it to go? That you didn't have a bunch of bumps in the road?
If it's not contested, I would say an average, look around like $700 to $1,000, plus dollars. There are different schedules. If you're buying a ton of properties, obviously there's some economies of scale there if you're doing the same stuff. So, what I'll typically do if somebody's buying a lot of properties, I'll probably, give them a better deal on that because it's not like I have to go to all those hearings. It's one hearing for all those properties, but it's quite a bit of work. I mean, I've had some sales where I've had so many properties, and I mean, everybody in my office, all their relatives, and anybody else like on the block I can get a hold of, I've got them licking stamps and sticking certified letters and stuff. I got some stories for that. And of course, the look they give you in the post office when you walk in with a giant box, and all the people in line as well. Actually, what you have to do, what you usually do is you call them up. They're pretty cool about it because they don't want that situation. So they'll schedule a time either where you can come in or you can bring it and drop it off, and then they'll take care of it. And then you show up later and you pick up all your stamped receipts and things like that. So and in my experience, some post offices are easier to work with than others. In Crown Point, they are awesome over there. They're so accommodating. And there are some that aren't too friendly, but we won't name it. We'll name the good names.
Go ahead. I can tell you St. John is terrible.
There's some smaller ones. The point is, if you got a bunch of stuff, you should call Crown Point and call them ahead. They're really happy to help, and they're happy to tell you the best way to do it. You don't want to be on your deadline on the last day, and you got to get it done, and then you show up, and everybody's like furious with you, and nobody wants to deal with it. Then you gotta get 10 other people to go to every post office, and all day you're just like cycling around. It's the point is, again, we never wait till the last minute. Right? We get these things done ahead of time because we don't want to avoid those problems. Last minute bad things happen. And you don't want that.
So that was uncontested. What about?
Again, contested, the matter is going to get set for a hearing, right? And so the first hearing is what we call a status hearing. Like any other lawsuit, you're going to show up and basically you're going to put a schedule together as to, okay, here's the time period within which if the parties are going to file motions or do this or that, it has to be done by this date. This is the date within which discovery needs to be conducted. In a lawsuit, discovery is your opportunity to request information from the other party, and they can do the same, and that can be, written form like interrogatories, answers to questions, produce documents, or testimony like a deposition, just like in any other lawsuit. And then once you're past that time period, usually you can settle by that time, but if not, then it's going to get set for a trial, and you're going to show up at the trial, and that's where I'm going to be there with all my notices. I'm going to go through everything I did, bam, 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 with the statute, and then let them try and say I didn't do what I need to do.
Well, I'm asking as far as fees, so would that start at like
Oh.
1,000?
It depends on how much time.
No, it just depends on how much time. Like I just billed at an hourly rate, and I think, depending on who it is, they charge different rates. I usually will charge something less than what my normal rate is, because again, most of the time, it's only gonna be a few things that need to be done, right? But it can go on for a while. I mean, I had one suit, I think for a while, it was probably one of the oldest ones in the county that went on for years and years, So it depends on how much is at stake. One other thing to consider, actually that I wanted to bring up is keep in mind, as I said, you got to pay those subsequent taxes that have accrued on that property before you're going to be able to show up at the auditor's office and get a deed. Now, sometimes properties go to tax sale because these properties are ridiculously overassessed, and there's no way that a property is worth that, and taxes shouldn't be what it is, right? Okay, but guess what? Until you're the owner of the property, you don't have standing to contest taxes. So keep that in mind as well. You're not going to be able to just say, oh, I'm going to contest it, and then they should reduce it because nobody should have to pay that. You're going to have to pay the taxes, and I don't think you can retroactively go back and get a refund. You can contest it moving forward. So, you're going to have to eat that if you get a property. So be mindful of that too, because you don't want to come to that realization a year later, and then you're thinking, oh God, And I've seen people just say, I can't afford to pay it, right? And then they just let their interest go. Or maybe they were in a good position, when they were buying at the tax sale, and then they had a couple, deals or whatever. They have no liquidity, and now, in Lake County, by the way, they changed the time frame. I think it's 150 days after the hearing date is when you have to bring all that stuff back and pay those taxes. So if you don't do that within that time period, then you're going to lose your interest. Okay, I believe you can request an extension, but you don't want to be in that situation. So again, if you don't have the money when it comes time to get your deed, that could be a problem too. So keep that in mind.
On the treasurer's sale, you said it was 110% for 6 months, the interest.
110% the minimum
115.
bid for the first 6 months.
Is there anything on the commissioner's side? for that interest?
Well, the commissioners is 110% of the amount paid, but it's a much shorter time period, right? It used to be on the treasurer's 110%, and then there was some legislator out there, he had it in for the tax sale, and he got a law passed, and they reduced it, which is not good for the county, because I mean, the whole point of the tax sale is a way for the county to recoup, that tax revenue and get these properties producing in the tax rolls again. And the people that were doing the investment theory and just deploying money to make interest on the money, well, it just made our treasurer's sale less attractive, to other states and counties that might have a more favorable rate of return on that investment.
Contesting the taxes. I've heard horror stories of people who tried doing it on their own and ended up with their taxes going up. And, the people who hire the professional who's not the professional, which is a con man, and ended up wasting a lot of money. Do you recommend someone, or do you?
You can hire an attorney to do it, which is, of course, the way I'm always going to recommend it, because, of course, I'm biased, right? I would compare Indiana to Illinois. In that case, Illinois, it just was, when it comes to real estate, they're just a little more on the ball.
I knew an attorney in Illinois that did it.
You always hire an attorney, they always contest it, right? In Indiana, who does it? Well, you can try to do it yourself. You can send them the form. You can hire somebody to do it. Again, you can hire an attorney, but there are non-attorney outfits out there that hold themselves out as experts in that particular area. I have never retained any of them, but if you do some research, there are a couple out there. So I don't know if any are better or worse, but yeah, if you don't understand the process, I mean, that's almost the whole separate, discussion. That's like the next seminar. Right?
Do you handle those?
I will handle them, or I'll refer them to somebody. It just kind of depends. It depends on the circumstance, really, and the county. I think Porter County is a little bit easier to to go through the process.
So in Lake County, are you protesting the taxes or the assessed value?
You are protesting the assessed value, which ultimately then when you add all the factors in, derives what your tax bill is, right? Again, so that's why with these parcels, keep that in mind in the beginning as well, because in another year it could be several $1,000s and maybe or more, and maybe you don't have it, or just don't want to have to spend it. So just factor that in again ahead of time. Hopefully. That, along with some other things, if you're ever going to participate in the process, will give you a little bit of foresight to say, aha, there's a trap that I just saved myself from a year down the road.
Great.
All right, well, again, appreciate y'all coming, and if you have questions, give me a holler. I'm happy to help with anything. If you just want to go over it again, I'm happy to set aside some time.
Did you say that you're also an estate planner, like an estate?
Yeah, estates trust and estate administration. That's actually, interestingly, I was talking to Donna. I think that's the next seminar because, especially because there were some changes in the law with regard to that. That's the other thing I see that confronts you. In Illinois, people hire me to assist with these processes, purchase and sale properties all the time because that's what people do, right? They don't do that over here. So, attorneys aren't as involved in the process as but I seem to participate in a lot of them. And one of them is situations like this with problems with quiet title. But another time that I'm called in a lot is the deceased owner. And I've seen it where somebody's getting ready to close that week. You say, okay, well, where's Martha? She's dead. So,
Title company loves to.
Yeah, so there are a lot of things, and actually the law changed.
I had a couple too.
The law changed a year ago. There are some ways to transfer ownership without having to go through a full estate process. So again, there's some recent current events in that, but yeah, that's one situation I find where I help all of you out a lot is with deceased owners and sometimes people have put an estate plan together where they got beneficiaries on everything, or they thought of everything, but they never did anything with title to the house. So, I might have like a single asset estate, like an estate just for a house, and I have that a lot. I see a lot of it. So, yeah, but there's a couple different ways to address it, and we can usually, depending on how quick you need to do it. Those situations we can clean up and get ready to go, pretty quicker than you might think. So.
Except if there's like 18 heirs and, the
Yeah,
house is
it
worth.
depends. Yes, everyone's different. So.
We never see that, Donna.
Right. Or maybe everyone's not getting along.
Never easy.
Well, good. Well, glad fun to come by again and see y'all. And
Thank you, Brad.
Thank you, thank you.
no problem.
Great.
I thank you for lunch, Donna. Thanks.
There you go.
Guys, next week, next Tuesday, the training's going to be on Moxie Present. We do Moxie Present training. Okay.
Where did Joe go?
He took off already.
Thank you. Enjoy the-
Is his mom here?
Yeah, I guess so.
Where's over here?